Hello. In the course of my practice as a lawyer, or sometimes mediator, or even arbitrator, uh, I read a lot of documents signed by the parties, particularly when it comes to real estate, like seller, buyer, promise to purchase, preliminary contract, deed of sale, and so forth. And there are many nuances and many caveats and things to think about in advance, but there is one which is kind of obvious, and yet it brings trouble sometimes. And we're talking about the signing of the documents. Particularly, as you probably know, many documents are by default drafted in French in Quebec. It doesn't mean that there is no option for English, but strangely, there are a lot of situations when people sign without even trying to read, basically like believing on somebody's word that this is what you are signing. And later, when often there appears a problem, they, those people, they bring it up like, I didn't read it. I didn't know. I didn't understand what I was signing. And unfortunately, it's not a very good argument. Why would people sometimes sign without reading, even in their own language, by the way? That also happens. Some people, especially when they buy their first property and they know that it's a complicated thing, and they trust specialists and particularly real estate agents, trust on their word, trust on their explanations, trust sometimes the sellers or the buyers, and so forth, mm, missing or being willfully blind to the fact that those people might have their own agenda, their own interests in this situation. Some simply neglect either being overconfident about their own intellectual abilities, like, we know what it is, we know. Particularly those who have some experience with buying and selling immovable property, real estate in some other provinces or maybe in the United States, and they assume wrongly that the situation is the same here in Quebec. No, it's not, at least not completely. Uh, some, and I'm sure you also encountered those situations, or maybe you can think of them, some specifically do not get into details, do not get into the reading, thinking that maybe later that might be their way out. Because, yeah, I didn't know what I was signing. I did not understand what I was signing. But that's not helpful for several reasons. Here are they. Uh, a contract, including a promise to purchase and the purchase itself of a real estate property or some other valuable property, is valid as long as it's free and informed, and as long as, by the Civil Code of Quebec, the intent of the parties matched. So they really intended the agreement to be this way. And with this phrasing, with this explanation, many people would think, oh, it will be easy for me later to say, no, 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 that's not what I meant. But the point is, and the Supreme Court of Canada supported this position, that interpretation is based, first of all, on the plain text of the agreement. And as long as it's clear, as long as it's not ambiguous, then it's presumed that what's written there was the free, informed, and matching intent of the parties. So saying that I had something else in mind, or I simply did not understand at the time, usually is not that much helpful. And if you want out of such a deal, such a deed, mm, you can be sued for damages at the very least, or you could be forced even to transfer the property to the buyer or to transfer money to the seller and then deal with the property because you agreed to that. How do we know that you agreed to that? You signed the plain text. You say, for example, that I could not read the text, it's in French, or I did not understand this legal gibberish in that French. The Civil Code of Quebec gives one other presumption, which is a presumption of good faith, meaning that if you cannot prove otherwise, it's presumed that the other parties involved were acting in good faith. They did not want to misinform you. They did not want to lure you into something that you did not understand. So it will be on you to prove that you could not understand, you could not read. It's not that you do not understand French, but that you could not do anything to understand before signing. And as we know about the Article 1479 of the Civil Code, which says that you're responsible for any damage that you could have avoided if you acted as a reasonable, prudent, diligent person, and that it was expected from you as from a diligent, reasonable person that if you do not understand something, you would not sign unless you've obtained a certified translation of the text, unless you made it sure that this certified translation becomes a part of the text, and there is stipulation that both texts are equal and equally valid, and it should be interpreted together in case of any discrepancy between them. And of course, as a reasonable person, you knew that certified translators or simple translators or interpreters, even, or somebody speaking that language who could come with you, those people were available, and particularly lawyers were available who could read it for you, explain it to you before signing. So if having all that knowledge, all those opportunities, being a just regular, mentally capable adult person, you still signed some document that you could not even read, or that you didn't bother to read, or having read didn't bother to understand, or seeing that the document did not reflect your agreement but thought, okay, well, later on we'll do something about that and so forth. It's your lack of diligence, it's your own negligence that causes the trouble, and therefore you will bear the consequences, your responsibility because of that. So, however obvious it might sound, do not sign a document if you do not understand it, because your situation before you signed is much better for you than after you have signed. And if you have any questions, well, verify with your lawyer before you sign anything, particularly in a language that you do not even read. Thank you and have a nice day.